session. Please be seated.
Okay, thank you for waiting. The record will show that the panel has been reconstituted and Justice Joseph Ditkoff has joined us, and Justice Eric Nyman is not here for the next case that I'm going to be calling, which is number 2025-0436, Regina HEFFELFINGER, I think I had that right, or Finger, versus David FALLACE. And please feel free to correct me with respect to the pronunciation of your client's name.
Morning, Your Honors. Peter Cooperstein on behalf of the appellant, David FALLACE. The judge abused her discretion in several components of the judgment modification. The first was an error in not reducing the base child support of $1,384 to the presumptive child support of $1,079. The guidelines permit a judge to modify an existing child support order. There's an inconsistency between the amount of the existing order and the amount that would result in applying the child support guidelines, or if there's a material change in circumstances. In this case, there is an inconsistency between the existing order and the amount if you apply the guidelines, and the court found there's material change in circumstances, not only in father's income, but also an increase in mother's income.
So let me just back up for a moment. You agree that the judge has discretion to make a modification as long as there's been a material change of circumstances. And in this case, the judge so found. You just don't agree with that finding. Is that correct?
Oh, I agree that there's a material change in circumstances.
Oh, okay.
Yeah, I don't think there's any dispute that both parties' incomes have substantially increased.
So then where's the abuse of discretion if the judge has found that the larger increase, if you will, is with respect to your client, and therefore made, as far as she was concerned, the appropriate adjustment?
On the presumptive, on the base child support or the additional child support?
Well, the material change affects both of them, does it not?
Yes, so on the base child support, the error was, I guess there's a couple of errors. One is the judge continued to use father's income of $400,000 and applying or considering the base child support, but it disregarded the increase of mother's income from $80,000 at the time of divorce to $152,000, an increase of $72,000, or almost, her income increased almost 50%. The court is disregarding that increase, but it's using all of father's income to pay child support, base child support, and additional child support. The court should have used all of mother's income of $152,000 in calculating the child support, and that's where the error is, and it's inequitable. The court chose not to modify the base child support order for two reasons. One is that she found that they deviated at the time of the divorce, and that deviation still exists, but that's not accurate. They deviated at the time of divorce by attributing income to father of $400,000, even though he was making approximately $312,000. That deviation does not exist anymore because he makes well beyond $400,000. There's no more attribution of income to him. If, for example, a payor was making $200,000 and they agreed to attribute $300,000 to him in calculating the existing support order, he comes back 2 years later and says, I want to modify and reduce my child support because I'm only making $225,000. That deviation still exists because he's still making less than the $300,000 that was attributed to him. The court also chose not to reduce the base child support because she was respecting their agreement at the time of the divorce, which is inconsistent, though, with not respecting their agreement in paying additional child support, where they expressed and intended to cap father's additional child support at $800,000.
So let me ask you this. At the time of the agreement, if the husband has $400,000 income and the wife has whatever she had back then, what would be the guidelines weekly amount?
Well, I don't recall what she was making at the time at the time of divorce. I just know that they attributed $400 to him, and they came up with, again, the $1,384 a week.
Right, but I'm trying to understand whether that amount is a deviation or not from the guidelines. If,
Well, I believe it, again, they deviated because they attributed income to father. Had they not attributed income and just used a 312, it
I
would have
thought
been
the
less.
parties disagreed at what father's income was at the time.
At the time of divorce, I don't think either party disagrees that he was making about 312 on his financial statement.
This says the husband represents that his salary is $300,000 a year. That wasn't true?
Well, 312, yeah. So it was 300,000, it was close. I apologize if it was 312 or 300, but, yeah, represent that it was 300, but he
I mean, it
attributed
seems,
400.
if everyone agreed that his salary was $312, it seems weird that you'd write, it is acknowledged by the wife the husband represents his current base salary is $300,000. That sounds like the husband thought his salary was $300,000 and the wife thought it was higher, and they decided to reach an agreement.
Yeah, I apologize, I wasn't counsel at that time, so I don't know why they agreed to attribute him. I don't know if he was making more prior to the time that he got divorced or not.
All right.
It was also error for the judge to order father to pay 10% of his gross income above $800,000 with no cap. Again, under Huddleston case, which I cited to my brief, it reiterates that to the extent possible, the modified judgment to take into account the earlier expressed desires of the parties. In this case, the judge did not respect that agreement, where they agreed that father's child support obligations would be only up to $800,000. Instead, she increased it and says, you're paying additional child support of 10% of all your income above $800,000, regardless of what it is.
You seem to imply that there could be no valid reason for that, period. And so therefore, any change with respect to the a payment of over $800,000 with no cap would be abuse of discretion no matter what. Is that your position?
No, my position is child support's rooted in determining the needs of the children.
And so here the judge addressed that.
I'm sorry?
Here the judge addressed that, right? She addressed the
Judge
needs of the children.
addressed the children's needs, which is defined in part by the non-custodial parent's lifestyle, but judge explicitly found that dad's income or his lifestyle had not changed since the divorce. So, and also, you know, mother's income, her expenses have increased from $88,000 to $126,000.
Let's back up. I want to zero in, if I can, on your allegation that there was an abuse of discretion by this modification, the over $800,000 and the no cap, right?
Yes.
So the judge, you agree with me that it's not an automatically an abuse of discretion, because there's certain factors. It can a judge can make that modification based on the presence of certain factors, right?
Correct.
So one would be the needs of the children, and she addressed that. And with respect to that, where was there any error in terms of how she approached that particular factor?
Okay, so again, father's lifestyle had not changed.
Mm-hmm.
I don't recall the judge making findings that the children's needs were well beyond the amount that she was already getting, up to $800,000. And she cites in her conclusions of law, this Cooper case, where it says the court found there was an abuse of discretion when a party's modified child support was excessive and not rationally related to the reasonable needs of the children. And that was echoed by a case, Smith v. Edelman.
Your point is that the amount is just simply excessive.
It's excessive, and it has to be rationally related to the children's needs. And the needs, again, are defined in part by the non-custodial parent's lifestyle, which the judge found hadn't changed. And then
So the wife argues that the record shows an increase in the children's expenses. Do you agree with that?
well, I guess the first thing is, she never asked for an increase in child support in her complaint for modification. So first of all, one can assume that she was able to meet her needs based on that.
Or she
So-
might just have said, let's not complicate this any further. But did the judge find an increase in the children's expenses? And was that finding, if it was made, was it clearly erroneous or was it supported?
Well, I don't recall what she
That would
said.
be a basis to increase
Yeah.
the child support, right?
Sure, but what I'm saying is, I'm not sure if there was an actual finding about the children's needs have increased, but I can tell you that the mother's expenses, which the judge found was credible, had increased from $88,000 to $126, which is an increase of $38,000 a year, which I'm not minimizing.
Mothers, you said expenses.
You meant
mean
income?
Her expenses.
Oh, her expenses?
Her expenses had increased by $38,000, but her income had increased by $72,000. So while her expenses have increased by 30, that represents only half of what her increase in income was. And in Smith v. Edelman, which is 68 Mass Appeals Court 549, they echoed the Cooper case that I just cited to, where it found that simply because a non-custodial parent's income has increased does not warrant an increase in child support where the children's needs are met and there's no disparity in the standard of living. And there was no finding that there was a disparity in the parties' lifestyles. Mother had remarried. She was living in the house that her husband purchased or owns. And I think that's akin to alimony, where in the Young v. Young case, which is 428 Mass 1, the court found that a percentage-based alimony award is not abuse of discretion, provided the actual amount does not exceed the recipient's need, which is defined as the lifestyle the parties enjoyed during the marriage. So, for example, if the court could enter an order of percentage base, but they need to cap it, they need to find a number that says, okay, the lifestyle, in order to maintain this lifestyle, she would need $300,000 in alimony. So I've seen cases where the judge appropriately had a percentage-based order, but only capped the alimony up to $300,000. And I think, again, it has to be rationally related to the children's reasonable needs, which again is based on the lifestyle. If I may go to the next topic, the miscalculation of the 2028 retroactive award payment of $133,400 that the judge ordered Fowler to pay. That was based on his 10% of his income above $800,000 that she added in the modification judgment. The problem is the judge specifically found his income in 2023 was at least $1,559,000. In that case, the amount of the retroactive would only be $75,900, not $133,000.
Wasn't there an extra, whether it was $600,000 maybe, that was going to be paid in January of the following year? As income for, was this 2023?
Yeah, I don't recall. I can just tell you that, you know, again, the judge found what his income was. And even if she, the CEO of Venture Capital testified that the father's estimated income in 2023 was $1.7 million. So I don't know if, even if it was another $600,000, I don't recall that, I apologize. But even if he did 1.9, well, if it's at 1.7 million, like the CEO of Venture Capital testified to, then the payment would be $90,000, not even close to the $133,000. I don't know where the judge came up with that. I can only, and I think that's
What is your response to counsel's argument that actually that was a favorable amount to your client?
I think that's, well,
I know you don't know.
yeah, no, I think it's
I
pure
don't expect you to say you
speculation.
agree with it. I'm just saying, what's your response?
Yeah, I think it's
how do you,
pure
how do you refute it?
Yeah, no, I think it's pure speculation how the judge came out with that number, and why didn't the judge, if that was true, then why didn't the judge find his income to be a different amount? In addition, the judge erred in ordering Fowler to pay the retroactive child support of $163,000. And she did that for several reasons. One is she found that he did not make a sincere effort to find a new job. Instead, spent the majority of his time laying the groundwork for establishing a fund. But yet, she then praises him and says,
Yeah, but she made meticulous findings with respect to what she found credible and what she found not credible when your client testified. Actually, if you look at it carefully, paragraph by paragraph, they're almost even. She found many instances where he was credible and not. And based on that, she found that he did not make sincere efforts to look for a new job, nor did she accept your client's representation as to why he declined to take the $200,000 severance. How is that wrong when it's based on credibility findings? So what can we do with that, even if,
well,
in any event?
I see my time's up, but
Well, you
may
can
I
answer the
that
question.
Okay, with respect to I could just tell you, I understand that what the judge found. I don't believe she found him discredible or not credible with respect to his job search, networking, internet, stuff like that.
Let me just put it this way, because your time is up. If we were to determine that the judge made that finding based on her credibility determinations, are we not bound by it?
I think the evidence is contrary to that.
Okay, but that's not my answer to my question.
Yes.
If we were to find that her finding with respect to that issue was based on credibility findings, are we not bound by it? If they're not, it's not, but if they are, aren't we bound by it?
Well, I think the standard is whether it's erroneous, right? So,
All right, well,
So-
I take your answer. Okay.
Okay.
I'll see if the panel has any further questions for you. And I see none. Thank you very much.
thank you.
Good afternoon or good morning.
Good morning, good morning.
Members of the panel, my name is Richard Nowich, and I represent the appellee, Regina HEFFELFInger. Now goes
HEFFELFInger,
by Regina
okay.
Altruder. Other than a miscalculation of father's retroactive payment of child support for the year 2023, which appears to be significantly in father's favor, as Your Honor highlighted, the trial court judge committed neither an error of law nor any abuse of discretion here. Her more than 450, as Your Honor, I think appropriately highlighted, meticulous findings, over 82 pages of single-spaced texts, after 8 days of trial, thousands of pages of documents that she reviewed, indicates that she thoroughly considered the totality of this family's circumstance, as she was required to do, as decisions of this court have required her to do, in entering her child support orders. My initial instinct was to rest on my brief, unless there were questions of the court, but for 3 very specific points that I'd like to highlight. Before I get into that, I would like to address some of the questions of the panel that were asked of my brother just moments ago. Your Honor, Justice Sachs, you're 100% correct that in the first week of January, when the CFO, the husband's CFO, was testifying before the court, he acknowledged that $900,000 was essentially being held back, and it was being paid to father the very next week for work performed in the prior year. That is absolutely in the evidence, and I believe the judge made a specific finding of that.
I see that on a chart on page 29 of your brief. It still isn't clear why that 10% of that 900 would be 90,000. Yet, together with the 75.9 income that, or 10% of what he'd previously been credited with, let's say, was 75.9. So 75.9 plus 90 is 165.9, yet she ordered 133.4 as the retroactive payment for 2023.
So I concede that I believe that the trial court judge's calculation was wrong, but based upon the record, this court can identify and make other findings so long as they're supported by the record. And in the brief, I've gone through to highlight all of the sources of father's income, including the $1.259 million in distributions that he conceded he received in the first 6 months of the year, his $300,000 worth of guaranteed base salary. So right there, there's 1,559. The record also reflects $225,000 paid from the company on behalf of the 3 limited partners, $75,000 of which I think is fair to attribute to the father. Then the court makes specific findings that insurance is being paid on his behalf that is added to his K-1. CPA fees, 401k contributions to his retirement account are also paid. And then we come to the $900,000 that the CFO acknowledges is for work performed in 2023. You add all of those numbers up, his income is well in excess of $2.55 million. Subtracting out his 800, the number is much larger than what the court ordered.
How confident are we that this 900,000 that was owed for 2023 doesn't get counted in both years?
The short answer, Your Honor, is I can't be confident that it is or isn't. All I can say to you is that the CFO of the company, a gentleman from the University of Virginia, testified that he determined that $900,000 was due father in 2004 work performed in 2023. Based upon the evidence that the trial court judge had before her about father's evasiveness, obstructionist conduct, and what have you, I think it's fair to infer that the court could certainly have inferred that the $900,000 was being withheld improperly and not going to be paid until the conclusion of the trial was over. It just so happens that we were inquiring of that particular question at the right time, and we elicited the right information. But at the end of the day, I don't think there should be much dispute, if any at all, based upon the findings that the court made, that the gentleman's income was far in excess of what she ultimately found, which was, quote unquote, at least $1.559 million. And in fact, based upon the record before her, the credible information that she found, it was more in the line of $2.5 million. So the retroactive payment due to my client for the year 2023 should have been much higher than $133,000. That's the point I'm trying to make. The 3 points that I'd like to try to just highlight before I rest on my brief, and very quickly, with the greatest respect to my brother, who I am fond of and I enjoy working with, none of the 9 cases that he cites in his brief support any errors of law. He cites in the first instance the Berkhume and Huddleston case. Berkhume was an alimony case, which, as subsequent decisions of this court demonstrate, are entitled to markedly different analyses as opposed to cases that deal with child support. I think the Jones case speaks to that. So the Berkhume case is an opposite in many respects. Berkhume, at its core and reduced to its nub, really stands for the proposition that in modifying agreements, trial court judges must take into consideration the parties' prior words that they used in a separation agreement to determine what their intent was. There should be no question that the trial court judge did that here, and she made specific findings reflecting that on a couple of different occasions. The last thing I would say about Berkhume, contrary to what I believe Father is arguing and suggesting to this court, Berkhume most assuredly did not preclude trial court judges from modifying merged agreements that deal with child support. It absolutely, positively did not stand for that proposition. Second thing that I'd like to say is the trial court's decisions here, and there were several of them, but the trial court's decisions here were well within and fully consistent with the Massachusetts child support guidelines and about a dozen decisions of this court and the SJC over the last 20 or so years. All of these cases are cited in the brief. All of these cases were decided before this appeal even being filed, and all of them undermine all of the arguments that my brother has made. And I'm just going to highlight a couple of them for the court. We have Hogan from 2016. We have Kavanaugh 1 and Kavanaugh 2 from 2022 and 2025. We have Jones versus Jones, 2022. We have Smith versus Smith. Your Honor, Justice Sachs, I believe you wrote the opinion in that case from 2025. We have Schuler versus Schuler, an oldie but goodie from 1981. There's the Brooks versus Paila that rejected identical arguments that my brother now makes today. Croak versus Bergeron from 2007. Thompson, Fugeri, Dennis from 1981, 87, and 1990 respectively. And most importantly, the case of Hefner, which is a 2020 panel decision of this court that dealt with recalculating, or rather the lack of an obligation to recalculate child support where the parties previously agreed to a deviation. That is precisely what we have here, and it is on point in that respect. The last thing that I will say is, based upon the record and the totality of circumstances that we have here, I suggest that it would have been an abuse of discretion and an error of law for the trial court judge to not do what she did. For these reasons, Your Honors, we ask that the underlying decision be affirmed, and we have asked and suggest that the court may wish to award fees.
All right, before you leave the podium, I'll see if there's additional questions with respect to your argument and the issues that you raised in your brief. From counsel, yes, you have.
Yeah, I do have one question. The judge didn't credit the father's testimony that accepting the severance agreement that was offered to him would have interfered with his getting a job in the venture capital industry. As I read the documents, that severance agreement would have imposed a new obligation on him not to solicit any institutional investors. That was not part of the original employment agreement. So that was a new provision. Are you with me so far?
100%.
Okay. So if he was not able, if he'd signed that severance agreement and he wouldn't have been able to go to another venture capital firm and solicit institutional investors without checking with Polaris, I guess it was, to see if that was okay with them, why wouldn't that have significantly inhibited his ability to find a job in venture capital?
It's a great question, Your Honor. A couple of responses to that. Number one, as you may remember, the judge determined that the father's testimony in that regard was quote-unquote incredible.
Right, but why, based on the documents? That's really my question.
And I'm getting there. So the second piece to the response to your very good question, Your Honor, is that the underlying document that he was asked to sign in exchange for a $200,000 or $150,000 severance, it didn't preclude him from applying for any jobs, which is what he represented to Judge Cafazzo at both the October hearing in 2019 and the January 6, 2020 hearing, that was his goal, that he was applying for jobs. The document that he was asked to sign did not prevent him from doing that. The only thing that document did with respect to his job search, independent of his desire and his dream of forming a separate venture fund, now we get into the Schuler versus Schuler argument of, waiting until you find your ideal job. The only thing he had to do was notify them of the entities that he was applying to. That's it.
But it says he can't solicit institutional investors for investments. So whether he forms his own VC company doing that, or he goes to some other company as an employee, once he goes to that other company, he still can't solicit those institutional investors without getting Polaris's okay. Is that correct?
I think that second part of your observation is absolutely correct, Judge.
Okay, so why wouldn't it, this is a person whose experience is in the venture capital sector.
His experience.
Why wouldn't that agreement have interfered with his ability to get a job in the very sector where he has been fairly, quite successful before he was ended at Polaris and very successful after?
His experience prior to starting his own venture fund, Your Honor, was as a W-2 employee for a variety of entities. TIFF, I think there was an Alaskan fund, there was a fund in Colorado for an Indian tribe. He was never self-employed. He went from job to job to job to job. He was pursuing his quote-unquote ideal job.
Right. My question is, maybe you've answered it as best you can. Okay.
Unless there are any other questions, I rely on our brief.
All right, I'll check. See nothing here. Thank you both very much. We'll take the case under advisement.
Thank you.
The panel is going to stay on the bench for a moment while Justice Ditkoff leaves us and Justice Nyman returns.